beyond the line of actual control. They are called the occupied area of Pakistan and Pakistan Kashmir. So those refugees are still unsettled. They are in thousands and thousands. And since 1947, 1965 and 71 wars, all our Islam are still unsettled. Now again there is another 300,000 people that are migrated of a particular community from Kashmir to the rest of the part of the India, and they are still refugees.
Thank you very much. I think we've come to the end of the session. There seem to be no other questions. Thank you all, the audience and the panelists as well.
And we're going to begin in about 10 minutes from now, and simultaneously another session on bribery and corruption is going to take place in the next room. So all of those who are interested in that can join your various rooms. Thank you so much. That is the relationship amongst judiciary, legislature and executive. So please kindly come on the dais. On the chair would be Justice Hussain, Chief Justice Bangladesh. Please, I think he's on his way. Yeah. All right. Sir is already here. Right, sir. Please, sir, may I have you on the dais? And the other speakers, please. Mr. Vijay Jawahar Dada, Mr. Justice Shamsuddin Chaudhary, Mr. Sailesh Mehta, Mr. Justice Abdullah Saeed. These are the speakers in the dais for this session. You can have them all on the dais. So, the chairperson is all on the dais. Thank you very much, sir. Can I kindly request, I'm calling upon once again, Mr. Vijay Jawahar. Then the speakers, I will now leave the dais to the speakers. I will open the speakers to begin about any time. So, you may call upon the speakers one by one.
Good afternoon, ladies and gentlemen, distinguished speakers. The topic of this afternoon is the relationship between the legislature, executive and the judiciary. Examination of all the three kinds of state power is bound to trigger tyranny. So was uttered by Montesquieu, the great sage. His prophecy was followed by the founding fathers of the US Constitution first, and by most of the former British colonies on their attainment of independence. They did concede that absence of separation of power can only mean authoritarian and authoritarian society. Democracy can neither nourish nor nurture. Although Montesquieu based his theory on the English system, it was generally perceived that three kinds of rule by the former Lord Chancellors were the countervailing factors. That stumbling block has, however, been removed by the Constitution Act of 2005. By distributing the function the Lord Chancellors performed in the olden days to three distinct functions. While the separation of power is indispensable for the progression of democratic order, it is also imperative to achieve the same aim, that harmony prevails among the functionaries of the three organs. as breakdown of tranquility would invariably entail havoc. It is mutually of respect and resolution not to transgress upon each other's realm. What is needed to attain this cherished goal, all the three organs must act in orchestra without intruding upon the domain set apart for the other. The Constitution of Bangladesh reflects a combination of separation of power coupled with desired checks and balances. As you know, we have written Constitution. So while the elected parliament enjoys virtual monopoly to legislate within the framework of the Constitution, save the President's limited power to pass ordinances, power to judicially review acts of parliament is retained by the Supreme Court. The Supreme Court can, however, strike off an act only if the same is repugnant to a constitutional provision. I mean the judicial review. In the same way, our Supreme Court can also declare otherwise an act aimed to amend the Constitution. We do for this purpose fully endorse and uphold the principle Chief Justice Marshall laid down in the case of medicine. Judicially reviewing administrative actions is quite a commonplace in our system. But again, in judicially reviewing such acts, we review legally of such acts, not its merit or wisdom. Although the government has some role to play in the appointment of Supreme Court judges, effective consultation with the Chief Justice for this purpose is mandatory in view of the latest decision of the Appellate Division of the Supreme Court in 10 judges court case in recent past. Lower court judges are appointed by a commission composed of Supreme Court judges only. We have a Judicial Service Commission headed by a judge of the Appellate Division of Bangladesh, has a specific provision for superintendents of the Supreme Court, High Court Division of the subordinate courts in all matters. Neither the executive nor the legislature has any power to remove a Supreme Court judge. As in the earlier session, I have already mentioned, power to remove a judge of the Supreme Court lies with the Supreme Judicial Council, composed of 3 senior-most judges of the Supreme Court, headed by the Chief Justice. And this Supreme Judicial Council moves when the President of the Republic refers the matter to the Supreme Judicial Council when the complaint is lodged before the President, or the matter may be referred to the Chief Justice, who may refer the matter to the President, and President in his wisdom, if he thinks that it is a fit case to be referred to the Supreme Judicial Council, then he may refer it to the Supreme Judicial Council for necessary action. With these few words, I call upon Mr. Justice Shamsuddin Chaudhary to address the august gathering. Ladies and gentlemen, Mr. Justice Chaudhary.
The Honorable Chief Justice of Bangladesh, the President of this session, my Lords, Excellency, the High Commissioner for Sierra Leone, ladies and gentlemen. I am supposed to speak on a topic which is titled Supreme Court's Contribution to Make Invincible the Progression of Democracy in Bangladesh. I will embark upon it shortly, but before that, because of some intervening events, I will address that aspect before I embark upon my actual topic. I noted with great dismay that a member of English bar, I being a member of English bar myself, I was educated in this country, I'm a barrister from Inner Temple, that he used this public forum to agitate the interest of his client. It's never heard of. I could never think of a situation that a counsel, admittedly representing a client, can use this sort of public forum to agitate the grievance, whatever grievance he may have of his client. This is not a courtroom. If he has any grievance, obviously he should have used the court in Bangladesh, or if he had any allegation with respect to the procedure, as he said, we have a very highly competent Supreme Court with High Court Division and the Appellate Division. He could have gone there to agitate that grievance. In fact, the matter has already been challenged before the High Court Division in Bangladesh without success. The constitutionality of the War Crime Tribunal was in fact challenged, and that challenge doomed into failure because the High Court Division found nothing wrong with the composition or the constitution of the War Crime Tribunal. I believe the Learned Counsel also committed contempt of court because although the Honorable Chief Justice of Bangladesh was not present in this room at that particular point of time, but to his knowledge, Mr. Cadman's knowledge, the Honorable Chief Justice of Bangladesh is and was present in today's seminar. So he must have made attempt to influence the Honorable Chief Justice of Bangladesh, who would preside over the appellate forum so far as the war crime accused are concerned. I can see a very distinguished Bengali barrister and other distinguished barristers. My question is, can a barrister do it? Is it permissible by the code of conduct of the English bar? Has he breached the code of conduct of English bar by using a forum, a public forum, not the court, to agitate his grievance? If it's not permissible, I wonder if somebody would take it up with the Bar Council of England and Wales so that he is taken to task.
Why don't you take it up?
So he has abused today's forum, today's seminar, and I'm saying it with due respect to Dr. Aggarwala, who is a long-standing friend of mine. The other thing is, the speech he gave did that have anything to do with the topic under discussion in today's conference. Today's conference is aimed to discuss accountability and judicial reforms. So did this Bangladesh war crime aspect have any place in today's topic? So he has abused it to gain his own personal, to make his own personal gain available to him. And also,
Justice Chaudhary,
yes,
1 minute I will interfere.
yes,
I assure you we will expunge these remarks
yes.
from our proceedings.
Thank you very much indeed. Thank you very much indeed. Because this was definitely not a part of the topic for discussion today.
Only on that ground.
Only on that
Like
ground.
everybody has a right.
And also, no, this was not a part of this topic.
Yeah, that's why.
And also, he spoke unilaterally. The other side, Bangladesh government, or the prosecutor side, were not given an opportunity to be heard and to be present, to keep themselves present in today's seminar. So that was also in breach of the basic principles of natural justice. Now, in respect to some of the allegations he made, since I am a member of the bench in the